Um, do you have something like, yeah, it's recording in progress. Very well, welcome for the first online book discussion organized by the Yale Comparative Administrative Law mailing list. I am Isamarik, professor of law at the University of Essex in the UK and in Louvain in the French-speaking part of Belgium. With Mariolina and Oren, more on them in a minute. I am one of the new organizers of the Comparative Administrative Law mailing list that was established by Professor Susan Ozakerman in 2008. At the time, it was the preparation for the first edition of Comparative Administrative Law handbook in Edward Elgard, and it triggered a renewal of comparative administrative law in the world in general, as some of you know, because they were part of this project. So the objective at the time was to foster space for exchanging across jurisdictions on development in administrative law, and development could be manifold in jurisprudence, legal, scholarly developments. So we have now the pleasure, Oren, Mariolina, and I, and the privilege to try to keep alive the spirit of these friendly, diverse, and informative discussions in our community of comparative administrative law. So we have started a number of initiatives recently. One is to identify national moderators conveying national development on the mailing list. And some of you are these national moderators here today. So thank you for you who have joined or in the taking. We will start a scholarly corner with monthly updates, thanks to Professor Eduardo Joado in June or July. And we also plan to have regular book discussions such as the one we have today. So you found on the mailing list. I will put in the chat the list so you can join at your leisure at some point. We are making a very strong start with the discussions and the book entitled Comparative Administrative Law, an introduction, authored by Professor Giulio Napolitano and Dr. Leonardo Parona. I think we will all agree that it is fair to say that this book provides fascinating exercise between macro and micro comparison, and it is extremely rich as an overview of administrative law across a number of jurisdictions in the world, both the global players such as the US, the UK, France, Germany, Italy, and China, but also less usual suspects such as Ireland, Botswana, Uganda, or Taiwan. So it's very rich. Let me first introduce our speakers. So Professor Napolitano is Professor of Public Law at the University of Roma Tre, a member of the Board of Editors of the European Public Law Review, and a barrister in Rome. So in his practice, he is mostly focused on regulatory issues and economic public law matters. Dr. Leonardo Parona is an assistant professor of administrative law, also at Roma Tre. Leonardo has a PhD from Trento in Italy and has been a research visitor at the Georgetown University Law Center a couple of years ago. So Oren Tamir is an associate professor of law at the University of Arizona. He earned an LM and a SGD from Harvard Law School and is mostly interested from reinvigorating comparative administrative law in the US. Professor Mariolina E. Antonio will be our second commentator, and she's Professor of European and Comparative Administrative Law at Maastricht University. She is focused on comparative judicial review and the enforcement of European law before national and EU courts. And then our last speaker will be Trevor Wan, who is an assistant professor at the Faculty of Law, the University of Hong Kong, and his research is mostly interdisciplinary, drawing from political sciences to study comparative constitutional and administrative law, as well as the law of coroners and inquest. His work in comparative administrative law is interested in administrative law in East Asia, the relationships between authoritarianism and administrative law, and the relationship between bureaucratic politics and administrative law. So I suggest we first hear from Giulio and Leonardo reflecting on the key features of their book, and then we will listen to our three commentators, and the speaking order will be Oren, Mariolina, and Trevor. And after that, the response will be given by Giulio and Leonardo, and we will open the floor to the audience with probably a lot of questions for this very rich book. So Giulio, Leonardo, I don't know who
Thank, thank you very much for your invitation and introduction. It's a great pleasure for me and Leonardo to be here together with you to present and discuss and hear about our recent book. And let me say also that I'm very happy of this opportunity and event because I was at the first conference in Yale, or now some years ago, let's say so. And I always had in mind this project to prepare a general introduction to comparative administrative law, which of course is not so complete because otherwise one would have needed volumes and volumes. But this is probably the first comprehensive and even if short introduction to comparative administrative law that was conceived and written in a unitary way by me and Leonardo. And maybe I can say that the book is divided in 6 chapters about the history and methods of legal comparison in administrative law, the rise and transformation of administrative law in Europe, the worldwide diffusion of administrative law, and then some horizontal and functional analysis of 3 main areas of administrative law concerning public functions, delegation, and outsourcing, then administrative procedures and action, and finally administrative litigation and judicial protection. We were well aware of the difficulty of this project, and of course our choices can be discussed and criticized with good arguments, but our idea, our purpose was first of all to combine an historical perspective with a very contemporary one, including the main open issues in government and regulation. Secondly, to overcome the traditional focus on Europe and US, on the Western legal tradition, from which, of course, we start, but we try to open bridges and enlarge the perspectives, analyzing the development of administrative law in South America, in Africa, in East Asia, and in Australia and New Zealand. We decided not to insist on the traditional distinction between civil law countries and common law countries that we consider to many extent outdated and not truly explanatory in administrative law. And we decided to combine the reconstruction of the historical development and of the various interactions between different areas of the world with a functional cross-sector analysis, cross-sector and cross-country analysis of the main institutions of administrative law on the side of administrative organization, changing borders of public functions, the use of contracting out and the involvement of the private sector in the performance of public functions, delegation to independent agencies, trying to select for each of these topics the most relevant national or supranational experiences. Then we focused our attention on the different models and instruments of administrative action and on the different attempts to regulate administrative actions. Of course, the regulation of administrative procedures around the world, as well as the regulation of public procurement with techniques that are different in Europe, in the European Union in particular, in the United States, and in other jurisdictions such as South Africa. And finally, we analyzed the different models and systems of judicial protection and administrative litigation. In this path, we of course made reference to the main let's say intellectual constructions of administrative law, but also we try to pay attention to the most important statutory developments and to the case law and the approaches followed by courts in addressing some of the most relevant transformations of administrative law across the world. We believe, and we stress this point at the end of the first chapter on the methodology of legal comparison in administrative law, I think we live as comparative lawyers in administrative law happy times, because the legal materials now are much richer. We are not anymore, as in the past, very difficult judgments from courts that were in the past unfoundable. Now we have an intense statutory regulation of administrative law, and this is related, in my view, to the increasing political importance of administrative law and regulation. We have a much more specific constitutional foundation of administrative law in written constitutions, and this was not the reality at the end of the 19th century and also for a large part of the 20th century. And we have judgments that are available online, often in English language, or with a much easier way to translate different languages. So we live, I think, in an extraordinary window of opportunity. And of course, this at the same time makes our work more difficult because you must propose and select the right lens. And of course, there is a wide margin of discretion, if we want to use this wording, also in writing a book on comparative administrative law. But I think that both for me and Leonardo, this was a very challenging experience. And I hope this will be a stimulating book for all of you. Thank you very much.
Thank you very much, Julia, for sketching the organization and key challenges. Leonardo, do you want to add something to that?
Thank you very much. I think Julia already made a very extensive presentation, so I do not want to steal time. Let me just maybe add a point that we long discussed, and also in the past years, which concerns the possible tension between convergencies and divergencies among the various legal systems concerned. Of course, this is a crucial and demanding challenge for a book that aims to offer an introduction, as has been said, to comparative administrative law. And it is difficult to seek the exact degree of specificity of the analysis, and therefore to strike the right balance, let's say, between emphasizing common features and to provide adequate explanations and take into account the divergences. It is well known, of course, that when in any scientific effort you look closer at the objects, the differences emerge. And the closer you look, the bigger the differences are. But since the analysis we conducted deals both with general and institutional aspects of the various legal systems, as well as with more specific ones, the functional analysis that Julia was referring to earlier, especially in the 4th and the 5th chapter, we deemed that the degree of specificity to be observed needed not to be necessarily the same throughout the analysis conducted in the book, especially because this is a flexible method, which is functional, we believe, to an introduction to comparative administrative law. But I don't want to steal more time at this moment. So thank you very much. And I'd like to hear from Mariolina and Trevor your comments.
Thank you very much for adding this important point about convergence and divergence. I think the book tried to trigger a lot of curiosity in the reader, and in doing the little nudges, I think it triggers some kind of attention on things to want, and the wish to go on. So on that basis, I would think it's a right balance for at least me as a reader. So I don't know what other colleagues think, but I will pass the floor to Oren to know more about what he thinks.
Okay, great. Can you hear me okay? Okay, perfect. Isul, maybe we can stop sharing the slide so I don't know, I see all your faces very in a very tiny, oh, that's perfect. That's better. Okay, great. So thanks Isul for expertly chairing this, and thank you Giulio and Leonardo for really a terrific book. You've talked about the challenges that you faced in the book. We're really happy, I'm really happy that you took on the challenges and wrote this book, because it is part of it's going to be, I think, indispensable in providing this introduction to the field. And, you know, it's not only enhancing the kind of the efforts and scholarship in this field, it's also, I mean, I can easily imagine using the book as a tool in a classroom in comparative administrative law. So it's both a kind of a really key reference point and a survey and a contribution, an analytical contribution to the field, but also going to be so important in getting other people easily introduced and emerged in the field. And I do want to say that I think some of the choices that you've made are really important. So the kind of the scope, the breadth of the book, and the amount, it's the amount of jurisdictions that are included and are discussed is just truly impressive. You know, in comparative constitutional law, there's always this blame that the field doesn't have. There are always usual suspects, and there's a real effort in this book to integrate more and more jurisdictions beyond the usual suspects. I liked also the kind of horizontal rather than vertical sort of discussion that is thematic rather than kind of jurisdiction specific. And I also like this, I like the fact that there's a flexibility in the amount of details that you provide, that you didn't feel that you're kind of like mandated to provide the same kind of detail, but actually let the amount of detail emerge or kind of be dictated by the substance of the discussion itself. So all these things are really terrific strengths. I'm going to try and raise 3 points in the spirit of kind of constructive discussion. Somewhat, some of the points are more critical, but others are just kind of to elaborate on thoughts that you yourselves put in the book. And I guess in a way also to kind of provoke you to answer something that I think was missing from the book. So I'm going to talk about some dispute that I have with your historical account of the emergence of comparative administrative law as a field. I'm going to talk about a point that you discuss in the book, but or raise the possibility of a decreasing U.S. administrative law influence globally, and suggest that there's more credibility to that suggestion, and finally ask you about the future of the field. So here's my point of history of comparative administrative law. You make the, I think, absolutely kind of immediately clear point that there's kind of a slow or delay in the emergence of comparative administrative law, certainly compared to private law, but also compared to constitutional law. The field was kind of struggling. It took time to emerge fully in the way that we can have these books that are kind of like your book that are central for the field and defining the field. And I think that you also observed some of the reasons for this, and in part it's kind of like the lack of uniformity in administrative law and the diffusion. There was a pretty quickly a kind of, or at least from the mid 20th century, kind of convergence in constitutional law, at least in kind of at the level of positive documents. And administrative law was really tough. You know, Justice Scalia was saying in reference to U.S. administrative law is not for sissies. Or it's like a very sexist term, but it was also, it's really complicated. It's a lot of technicalities, and these create barriers. And you also talk about the kind of differences that administrative law is really connected to kind of visions of government and the state that are really importantly different across systems. And that sort of created kind of the delay in the emergence. But I want to suggest that the story is somewhat more complicated. As I see the history of the field, the story is not that linear, that there was kind of a delay and then sort of blossoming of the field. I think there was actually a point in time where comparison was really, really important at the start of modern administrative law. And then it sort of slowed down, it tanked, and then it rose again. And I think that's a more important story to tell and a more kind of accurate story about the field. So I want to just rehearse some of that. And I also want to add something to the reasons for the not necessarily the kind of slow or delay, but the kind of tanking of comparative administrative law. What were the reasons? So let me start by just saying very briefly about why the story isn't linear. So as I see things from a US perspective, comparative administrative law was key in the emergence of administrative law in the US. It played a huge role in the thinking of how to actually develop administrative law. So the most important scholars of administrative law in America were consistently looking across comparative lines. What is going on in France? What is going on in Germany? And actually, until the 70s, more or less, what we're seeing is essentially a consistent tendency to look at and define one's comparative administrative or one's administrative law system through comparative engagement. We see this in the work, and I won't give citations but the references, but the story is really about kind of a lively comparative engagement that dies down in the 70s. And then the curious question is, why do we see this kind of tanking of comparative administrative law? And I think the story, and this is where I want to say, it's not only kind of the non-linear story, it's also a story, I think, that is about politics or the sociology of kind of the legal profession. So I think two reasons that are really important in the story of the tanking of comparative administrative law, at least from a US perspective, or at least from a European perspective, is that the politics of it, I mean, at the start or the emergence of modern administrative law systems, it was really, really, it was, oh, sorry, my new headsets are falling from me. They were really, really interested in kind of justifying and building an administrative law in conditions that were kind of hostile for the emergence of administrative law. In the US, there was a very kind of constitutional law that was libertarian in tendencies, that was resistant to the creation of administrative law. The common law itself was kind of resistant in important ways. So the comparative administrative law is really important in building an administrative law project. But once we had the project itself already set, it was less necessary. Comparative administrative laws kind of disappeared in a way. So I think the story about the politics of comparison is really important, the tanking of why it disappeared and why we're seeing it sort of emerging. And another point I want to say, again, from a US perspective, why the tanking and then the kind of rise, I also think that the US, or at least in many other countries, there's less of a kind of an international focus. Many people who teach administrative law, write in administrative law, don't speak other languages, don't have the kind of closer ties to other nations. So again, there's a kind of a sociological story and a political story that I wanted to emphasize. So this is somewhat of a kind of a bit of a complication of the historical narrative. Let me say more briefly another point about the declining US influence. So you mentioned the fact, you raised the possibility in the book that the US was really influential in administrative law, at least starting perhaps the 80s as a kind of an exporter or an influencer. And then you have one sentence where you raise the possibility maybe the influence of the US is declining. So I want to suggest some credibility to elaborate some of the credibility in the thought. So here's some reasons why I think you might be right. Here's one reason that's famous. So one of the US focus or kind of inspirations or reasons that made the US such an influencer or an exporter. And Izul, please tell me when I'm reaching time, because I've completely lost my timer. Okay, so you'll tell, I have 1 minute? 3, perfect. Okay, so it gives me a great, exactly the time that I need. So one reason that the US was so influential was Chevron deference, right? The idea of deference. Even if systems didn't necessarily take that, it was kind of like a reason why people consistently looked at the US. And so one reason Chevron that used to be so influential is no longer here. And I think the US no longer is a leader in the thinking of how to do deference or how to incorporate the views of non-judges, to defer to administrators. Maybe, by the way, the new kind of leader in this field is probably the only jurisdiction where I know that there's a kind of an emphatic doctrine of deference that is really broad and encompassing is Canada. Maybe Canada will become more. So Chevron is no longer there. Here's another reason. Notice and comment process that the US is so focused on. I think also the importance of notice and comment is decreasing in the world. I know that people are thinking about it, but I think if we're looking at how regulation is done, there's an increase in the use of soft law and guidance instruments. And I think that the law of soft law, to the extent that that's going to be the kind of key and the focal point for administrative law, we actually have other systems other than the US with a more elaborate, sophisticated system of law to learn from. So I think that's another reason for US decreasing potential influence. And finally, of course, you can't not mention that in this context, the influence of the Trump administration. And here, of course, I'll just say, again, we don't know the story. It's still playing out, but the increasing US isolationism in the world might further decrease the influence of US administrative law. And another possibility is that the Trump administration, to the extent that it is perceived as a negative one, it would be a kind of a bad precedent for executive unilateralism and administrative law that people, I mean, other jurisdictions would not want to imitate. Okay, so this is some to flesh out some of the reasons for why the US credibly might be decreasing in its influence in administrative law. And I'll end with one question for you because I don't have time. So one question that I had for you is that this book is so great and giving us so much information about the field and to kind of introduce and to flesh out what is the field about. But I'm really curious because you have this amazing panoramic view and knowledge of what is going on in administrative law. What is the future of the field? What are the next frontiers that you see that you think that more work, more scholarship, more thought should be devoted to? So it's a question for you rather than a critique from your kind of unique vantage point after writing this book. Thank you so much for this terrific contribution.
Thank you very much, Oren, for your thoughts about the book and asking questions. I'm also very much interested in hearing what Leonardo and Giulio think about the future, but we will leave that for after the general discussion. Mariolina, what can we?
Yes, thank you. Thank you very much, Iseult, and thank you very much, Giulio and Leonardo, for accepting our invitation to discuss your book. And well, speaking about the usefulness of the book in the classroom, I can already testify that we have started to use the book, parts of it for my course on comparative administrative law that is taught in the Bachelor European Law School at Maastricht University, which I coordinate. So that's already one very, very practical application of the book in the classroom. So thank you very much for providing us the materials for my course. What I would like to discuss with you both today, also partially building on what Oren mentioned moments ago, are a couple of methodological choices, or rather I should say methodological challenges in writing such a book. You both know, and some of the people in the audience might know, that I have been working also on some well, projects, let's say, related to comparative administrative law, including starting from my own PhD thesis a geological era ago. And so when I was reading the book, I sort of grappled with, or I came back to a number of methodological challenges that I encountered in the past, and which I also discussed with Oren in a previous discussion on a paper he wrote on how to do comparative administrative law in the US. But I think certain methodological challenges are the same everywhere. And when I was discussing with Oren on his paper, one of the points that he was making about using more comparative administrative law in the US, one of the conclusions he reached was, well, it's good to use comparative administrative law, but one should do it properly, because otherwise it will do more bad than good. And this comes with a number of methodological challenges. And in the past, I have called them, and I want to discuss them with you today, 4 dangers. The dangers of the unknown, the dangers of the unwritten, the danger of the unsaid, and the danger of the unspoken. And so I come to these 4 dangers in turn, and I will add a 5th one for the grand finale. And what I basically would like to ask you is whether you have experienced these dangers in your work, and how you have managed to overcome them. So the first one, the danger of the unknown. My experience in doing comparative administrative law is that if one doesn't know precisely what one is looking for, it will be difficult to find it. So, for example, when we were working on our casebook on judicial review and English, we realized that a notion of factual action, which is so prominent in Germany, does not exist in England. So therefore, an English lawyer will never go and search on how to conceptualize factual action in Germany, because this is a non-issue in English law. And a German lawyer will be at the same time astonished that there is no discussion of what qualifies as a real act in English law. So when we were working on the book at the time, the astonished German colleague looked at the English colleague and said, "But you surely have police cars that are driving around in England, don't you? So how do you qualify this administrative action?" And the puzzled face of the English colleague spoke really volumes about the perils of doing a comparative administrative law. So one should be aware of what is there, but also of what is not there, because it might be as important for the comparative lawyer as what is actually there. So that would be the first danger that I encounter, the danger of what is not there, of what we don't know, the danger of the unknown. Second danger that I came across was the danger of the unwritten. So it seems to me that there is more to understanding a legal system than just the law in the books, but also the law in the case law. There is more to a legal system than what we can find in writing, let's say. So, for example, dating back from my own PhD research, I had to investigate, amongst others, the ex officio powers of national administrative courts. And I could not find any rules about that in the English legal system. So when I asked a barrister, he looked at me and said, "Of course, we can raise points, including points of EU law ex officio. It's a matter of fairness." And I said, "Yeah, but where can you find it?" And he looked at me and said, "Well, it's a matter of fairness. It's not written anywhere." So again, one should be aware of also, what is written, but also what is not written, and how can one do comparative administrative law when one has to navigate also through all of these kind of unwritten rules and principles. So yeah, the danger of the unknown and the danger of the unwritten. The third danger was, to me, what I label here today, the danger of the unsaid, as I should say, maybe what there is more sometimes than what meets the eye, in the sense of, for example, if we take Wensbury unreasonableness or the principle of proportionality, we all know what they mean in the abstract, let's say, but when we go and apply this concretely, it may end up meaning many different things at the same time. For example, I learned when doing comparative administrative law that judges apply sometimes Wensbury unreasonableness in a very thorough manner that comes close to proportionality, and also that German judges do not always very religiously follow the 3 steps of proportionality that we all learn and that I also teach to my students in comparative administrative law. So sometimes there is also more than meets the eye in a doctrine that we consider as a straightforward doctrine in administrative law. And then comes my final danger, which is the one of the unspoken. And that is something that well, Oren was mentioning before about many US lawyers not speaking other languages. And you also in your introduction mentioned the fact that there is many more tools these days to help and support research in different languages. I wonder really how one can do really comparative administrative law without knowledge of the legal system, and how you managed also to overcome this difficulty. And I've come to, well, then my very final point, which is not about an something, but I will call it the danger of the touch of stateness. And what I mean is the following. There is a paper by Felipe Brito Bastos in the German Law Journal of a couple of years ago, where his argument was that it is difficult to really to study European administrative law as an autonomous discipline because we all come with an own national administrative law set of glasses, and therefore we try to apply that kind of set of glasses to European administrative law, whereby we should be, getting rid of those glasses. The conclusion of Felipe, however, being that it's very difficult, because if we get rid of those glasses, we don't have a comparative set of glasses that we could put on. So did you feel also that you had this kind of touch of stateness in your work and in your comparative investigation? And is there a way to get rid of the touch of stateness? There we go. Thank you, Iseult.
Thank you very much, Mariolina, for just being under 10 minutes. So that's a challenge. Great. It will leave a little bit of time to Trevor to move to his own comments. Please, Trevor.
Thank you. And but first of all, let me thank both authors with the immensely, really interesting book. I struggle to think about how to apply it pedagogically and how to apply to your classrooms. It's going to take me some time, but at least I have something to start with, which I'm happy. Now, today I'd like to make 3 points. First, about the parameters or the definition of administrative or comparative administrative law. Second, about diffusion as a concept. And thirdly, some jurisdictional boundaries that we're mentioning. But let's go to the first point first, about definition of the field. Now, this strand of discussion actually has come out already in Oran's discussion, and also Mariolina's discussion about what exactly do we mean by administrative law? How do we define the contours of this field? Now, I think one of the biggest issues that we face in comparative administrative law really is, what do we mean by it? Now, a French lawyer may think administrative law is encompassing A and B, while a lawyer in Australia may mean encompassing A and B and C, and while a Hong Kong lawyer may mean only A. Now, this is a big issue that complicates our work, and it could be attributed to things like formal classification of law that differs among jurisdiction. It could be a difference because of epidemic divergence, what scholars talk about. It could be because of practice lingos, or it could just be because of understanding, common understandings that we have respectively. So what I particularly like this book is because it gives us a very workable, or give us an operationalizable framework to see what exactly could be at least packed into this framework of administrative law. Here we can easily compare with comparative constitutional law, where at least, as Oren mentioned, you have this big small C document with the name of constitution where you can start working with, that could be used as a lot in mathematical terms, the LCM. You have the least common multiple. But administrative law, we struggle to find that least common multiple, and I believe really this book helped us to find that LCM. And but at the same time, it helps us to think about how it breaches these sort of understanding of administrative law, because as we all know here, there's this issue of kind of like methodological nationalism that underpins comparative research, that we may have some subconscious biases that comes from our jurisdiction that limits how we understand, how much we can understand. And I think this book helps to remind that we could go beyond this methodological nationalism and think about how administrative law could be conceptualized elsewhere. And that is the first thing I like to really commend this book, and what gets me into thinking, really, what administrative law is and what could we theoretically be included in it. And this is important because at least it gives the scholar a sort of a first initial parameters to work on. And that's the first thing. The second point I'd like to make is about diffusion, which constitutes a pretty large at least 2 chapters that I see within the book. And I've a little bit of quick tip here. But so when we talk about diffusion, I think we mean there can be many things that we mean. First of all, do we mean diffusion of administrative law as a whole, as a subject across countries? So you have England diffusing maybe the institution of administrative law to its colonies, for example, Singapore, Hong Kong, Malaysia, for example. Or you could mean diffusion of specific doctrines, diffusion of specific institutions, and diffusion of specific systems of law. And I think this is where the book here, we may not be 100% clear about, is what is the type of diffusion that we're talking about, and to what extent, and to what is the specificity that we can get when we talk about diffusion. Because when we try to, it ties to the issue of explanation, of explanatory work. When we try to look at diffusion, we usually we have to ask, why does this diffusion occur? Why does this diffusion occur in one country but not another country? Or why a diffusion occurs in one country and it manages to consolidate versus while in another country it has not been able to consolidate? And I think to successfully answer these sorts of explanatory questions, we have to be specific as to what we are talking about when the unit of analysis that diffusion is attached to. We have to be specific as to what kind of things that we're talking about, that we're saying is being diffusing across jurisdictional boundaries. Again, entire systems, doctrines like Chevron deference, or institutions like ombudsman, audit commissions, or other sort of independent commissions. And I think this book has given us, again, a working parameter or a working basic knowledge of what diffusion could look like in administrative law. And it's sort of like an invitation for us to go further and look at the diffusion of specific institutions and try to engage in explanatory work and explaining this diffusion. Now, I recall that in a very early stage of the book, actually, Leonardo and Julio, you guys raised a number of possible hypotheses as to why diffusion occur. For example, it could be, could be because of international competition. It could be because of international pressure, like you have IMF, you have those trying to impose the sort of administrative law institutions. I think an invitation from this book would be for us to really engage in very serious explanatory work, drawing on politics, economics, sociology to explain precisely, first of all, again, why institutions diffuse, and secondly, why some institutions manage to endure and why some institutions do not manage to endure. And I think another very specific factor that is clearly emerging in the book is the role of history. The role of history and the role of path dependence that impacts upon the endurance of the consolidation of institutions. Like you have history affecting Australia, New Zealand, and also African jurisdiction. And I think we have to consider this variable seriously. And that's the second broad point that I have. And the third broad point I have is about the breadth of jurisdiction. Now, coming from Asia, I really, really appreciate the book's immense efforts in engaging jurisdiction, the less usual suspects, especially those in Asia, like China, Japan, Korea. I would have hoped Hong Kong is included, but it doesn't matter because we have similar common law countries, common jurisdiction as well. But anyway, I'd like to just flag a few points as to what more we could done with this kind of jurisdictional diversity that we have, or what why are we trying to include more jurisdiction? We should not be including them just for the sake of inclusion or diversity. There should be some reasons for us, and I believe there are some diverse and I think these jurisdictions offer certain diverse administrative experiences that is worth referencing by lawyers. And first one is that in Asia, at least in Asia, I think there's a very important linkage between authoritarianism and administrative law. That administrative law essentially is a kind of a tool for authoritarian rulers to maybe police the agents, mitigate principal agency issues, or even to control central local relations. I believe these kind of Asia is interesting experience in terms of how administrative law is used to mitigate certain dilemmas arising from authoritarian rule. I think China is a good example. I heard in Malaysia, Singapore, etc., offers another good examples as well. And that's the first thing. Second thing is about how Asia offers experience as to how administrative law interacts with central local relations. Again, how administrative law manages the tension between central local relations, and also about how administrative law could be pluralistic within a certain jurisdiction. And I have in mind, again, the example of China, because in China, there's actually at least 3 parallel administrative law regime working. First of all, you have the People's Republic of China, administrative law regime based on Chinese law, socialist law. And then you have Hong Kong, which is a common law jurisdiction descended from English common law. And then you have Macau, and Macau has essentially is a Portuguese legal system. So you have this kind of administrative law, central local relationship, but you also have this administrative law pluralism within one giant jurisdiction. And I think these are very, very interesting questions that we can explore. For example, again, why do we have this kind of pluralism? What sustains this kind of pluralism? And what is the instrumental value in it? And I see, again, this book, the jurisdictional diversity, as inviting us to further think about how the other jurisdiction experience inform the broader canon, or if I may use the word, of comparative administrative law. And these are basically the points that I have for today. And I also like Oran ends with one particular question for Leonardo and Giulio, which again goes back to something I've said. Going forward, in terms of the future of the field, as Oran said, what both of you think about what kind of explanatory work we could engage in? What kind of explanatory questions that you think the field will be engaging in, or will we be enthusiastic as to this particular field of study? And I would like to hear more about that as well. Thank you.
Thank you very much, Trevor, for your challenging questions and comments, but also very rich from a slightly different part of the world. I would suggest, Leonardo and Giulio, you may react to what has been said, the positive things, and maybe also the slightly more challenging points, maybe for maximum 10 minutes, so that we can leave a little bit the space for the audience to please.
Yes, I will start and then I will leave the floor to Leonardo. Thank you very much for all your comments and observations and questions. I want to stress, first of all, what all of you said, which is the importance of this book for us, for the students, because we really, I'm teaching comparative administrative law in my university in Rome since 10 years, but beyond this egoistic and practical need, I really felt the cultural need of a book which is manageable for students. We had, of course, the amazing books edited by Susan Rose Ackerman. I take the opportunity to greet her. I see her in the list of the people participating. And it was really a stimulating and challenging experience, the one we made all together in Yale many years ago with the 2 editions of the book. But of course, students need something which is easier and much more immediately understandable. And this is also the reason why we decided to provide these very short paragraphs with titles to help students to have always clear which is the main topic and which is the context. And I think that comparative administrative law needs the energy and the passion of students, exactly because, as some of you was saying, apparently administrative law is not so sexy as other areas of law. So I think we need to capture the attention of young scholars since the beginning. And so this was one of the purposes of this book. And of course, we tried as far as possible to have a double level of reading and analysis. So a book which has, we hope, a very clear explanatory part for students, but also we give our reading of the reasons of the development of administrative law. We try to provide a logic in the organization and development of administrative law. And we try to provide some lines through which reading the transformation of administrative law. And this is, for instance, exactly the case of the grounds and causes of convergence and divergence in administrative law, as you were rightly underscoring. So I will pick just a few points from the very rich arguments you raised. First of all, I agree with the comment made by Oren that the development of comparative administrative law was not linear, and I agree that there was not start with a low level and then a gradual rush and rise. And this is also the reason why we mentioned the book Goodnow since the beginning, and we know that, and I agree that administrative law in the US looked at other very meaningful experiences around the world, and in particular in Europe. But I think you are right, this is true in many cases and in many jurisdictions, and the influences in some cases are rather surprising, as for instance the relationship between the German public law culture and the development of constitutional and administrative law in East Asia, or the very strange patchwork that was realized in South America, combining the different experiences of the US constitutionalism and of several European countries' administrative law. So I think he is perfectly right, and I also agree with the additional arguments you provided to suggest a potential crisis in the capacity of the influence of the US administrative law. We will see, and for sure the Trump administration will give to all of us very strong arguments and occasions of reflection and studying. I will leave to Leonardo to make additional comments. Just let me say that I agree with the concerns expressed by Mariolina, and about the potential mistakes in comparative law, which are always around the corner, and we do hope not to have made too many of them. But in some cases, it's better to run the risk than stopping. And I also really agree about the point made by Trevor on the relationship between authoritarianism and administrative law. And I still find very persuasive the analysis made by Tom Ginsberg about the relationship between the change of the political system in South Korea and in Japan and the transformations of administrative law. Just one point about the future potential developments and trends in administrative law. I think that some of the old stuff, let's call it in this way, is always very and dramatically interesting and stimulating. And this is particularly true in my view with reference to the relationship between politics and administrative law. We see this once again from what is happening in the United States, but despite the fact that old school lawyers kept away from political arguments, I think that one of the most encouraging and important contribution from the US legal scholarship was exactly to push all of us to study and take into due consideration the relationship between politics and administrative law. And of course, the other major trend I see is the relationship between technology and administrative law. But I will stop now and give the floor to Leonardo.
Thank you very much also on my side for the very rich comments and for the questions as well, of course. Let me just say that I can still say that I am young. So for a young scholar to write having in view students is probably even more difficult than writing different types of scientific works. And so the 4 dangers mentioned by Mariolina become even require even greater attention when you're writing having in mind students. On this first point, I would like just to say I completely agree on the fact that it is difficult to get rid of each own's glasses. But an alternative way of seeing this aspect could be not getting rid of those glasses, but being aware of the glasses that you're wearing, declaring them, and declaring the way that the point from which you're looking and analyzing things. Because if you pretend to be as neutral as possible, probably then you might occur into some misperceptions or not avoiding all of them. But this is just I realize that it is not an answer, of course. On the points made by Trevor, we can only say that this is the first edition. So in the second edition, we will try to add more references about Hong Kong. I will study more about Hong Kong legal system, and we will, of course, take in the advantage of your help, which is more than welcome, of course. But since you all, both Oren and Trevor, you made questions with regard to the future questions, future topics, and possible developments. Of course, I'm not in the position to make predictions, and Giulio Napolitano has already made reference to most of to many of them, especially with regard to something which is already present, not future, that is technological innovation and the regulation and use of AI and how it is changing the way in which we are conceiving certain functions, even before regulating them. I would also add another topic, another field of inquiry, which is, I think, fruitful for comparative analysis, and that is starting from the point that administrative law concerns the regulation of the way in which public authorities try to ensure the public benefit. And we live in societies which are becoming older and older, and which are showing new social needs. I think we should look more closely to the problems posed by the welfare state, so the disbursement of benefits, and welfare in a also in a, let's say, more holistic view, taking into consideration the issues posed on health by the climate emergency and environmental protection. So this sort of integrated approach, it's quite confused. Of course, I know this, but welfare state, the new welfare state, is something that from the comparative point of view, I think we should look more with greater attention, let's say. But thank you very much. I stop here.
Thank you very much for all your comments and explanation, the 5 of you. Shall we go to the discussion? I don't know if there are any questions from the audience. I do not see any.
I didn't put my hand. I'm waving my hand. I don't know how to. Where do I? Can I ask a question? Okay. Can you hear me? Okay. So this is fascinating, and I'm really looking forward to reading the book. Looks wonderful. A couple of questions from the comments that you were making about it, and from the commentators. The first question is more about soft law. I mean, I didn't quite understand what it means to have law applying to soft law, right? I mean, there's something like an executive order or a memorandum or some kind of a vague thing. And there's a lot of questions about what they mean. We've seen that in the U.S. case having to do with under the first Trump administration, having to do with the memorandum ending enforcement of the immigration laws against people that came as very young kids and went to school here. But anyway, I was confused about what you were thinking about, what you might be thinking about. Second, more kind of general question is that it seems to me there is back to several of you are mentioning the relationship between law and politics, particularly Leonardo's comments right at the end about the welfare state, right? I mean, I coming into this field out of social sciences, out of law and out of economics and political science, have always come into this field by saying, okay, what kind of problems are there that the law is trying to solve through legislation or through regulation, through case-by-case adjudication, and how do those differ across countries, and how is that related to the politics of the way in which policy is made, and that seems to me to be to some extent in tension with the idea that there's this field, called administrative law, and some of you, the rest of you who are lawyers, might react to that a bit, because I guess I've come in with a particular interest in regulation, rulemaking, not so much adjudication, although recognizing, of course, that's an important part of things, and seeing in the comparative stuff that I've done that one of the things that happens is that in at least in Germany and maybe in some of your other countries, when something gets defined as politics, then it's not law, right? Then the courts say, okay, we don't review that because that's a political choice, and then in the US, you've got all sorts of ways in which law is affecting policy. So it's a question of where the border is at the, do you want to draw a sharp line between law and other things and we're only doing law? Or do you have, as I think Leonardo was suggesting, we have a set of problems that the modern regulatory welfare state is facing, some of which overlap very much in a kind of conventional administrative law and others don't. And so I'm just asking whether you have some kind of observations or thoughts about that, because it's a rather different way of going into a set of issues that I think we're all interested in.
Thank you very much for your question. Do you want to react in some ways, Leonardo? Because you were, I think you were the one making the point, or Giulio as well, but yeah.
I go first. Okay, thank you. Thank you very much also for being here. Let me just say, I don't want to steal time, but let me just say that I've learned a lot from a lot of your works, and it is really an honor for me receiving a comment from you on this. I hope I fear that I might disappear you with my answer, since I can only say that it indeed is a field in which policy preferences or political choices really determine the way in which regulation is built. And so regulation both in the framework of the eligibility criteria and then in adjudicating, so deciding whom has to receive a benefit or not. And but also, and this is the relation between politics and also economics. This is a field that it's something banal what I'm saying, that really suffers from the lack of resources. So if you do not have and it is probably an aspect which I personally will have to work a lot on, is a due account of public finances, the studies on public finances, how they shape policies, and then how the law translate these policies into rules that administrations then have to enforce and apply. But these are just introductory and very confused thoughts at the moment.
Thank you very much, Leonardo. Giulio, do you want to add something? Or there is a question also in the chat, as you prefer.
No, maybe just to thank once again Susan for being here and for her comments, and of course the study of the relationship between politics and administrative law has a lot to do with her studies in the past, and I understand her skepticism about the distinction between hard and soft law, and this is the reason why we also try to pay attention to some very relevant, for instance, executive orders in the development of US administrative law. It's very important to keep always in mind the relationship between the different legal tools that governments can use to promote their policy.
Thank you very much. I think Dominic de Kogan has a question. Dominic, do you want to explain your question, or do you want me to read the question in the chat? Dominic? Okay, so Dominic is asking the question about the first thing that you said, that you wanted to leave aside the distinction between civil law and common law, and you said, I think, Giulio, yes, it does not make sense very much. And Dominic is asking you if you could explain a little bit more why you think that it is not relevant, or not so relevant in administrative law. Maybe also, it's my question. Do you think it's not relevant in general anymore, or it is not relevant for comparative administrative law in specific?
Thank you for this question. there are a lot of contributions in the general area of comparative administrative law that raise doubts about the usefulness of this distinction, including the very important book by Sims on comparative law. I share this opinion, even if the distinction has, at least historically, some important foundations, and so it is correct and useful to understand the historical development of legal orders. But I think that if we focus the attention on administrative law, we can say that, for instance, in France, which is, of course, the champion or the model for the so-called civil law system, this is true for civil law as a consequence, of course, of the enactment of a civil code, the Code Napoleon, and of the development of private law in France. But the development of administrative law in France is much more common law style. It is a judge-made law. Historically, is a judge-made law, and it's somehow paradoxical that France was really a latecomer in the statutory regulation of administrative procedures, because they only approved a code on the relationship between the public and the administration in 2015, while the United States, that is assumed to be strongly linked to UK and to the history of the English legal system, was the champion of the statutory regulation of administrative procedures. And I think that also the traditional distinction between the role played by ordinary courts and the role played by administrative courts is not so meaningful nowadays, as there have been so many changes and reciprocal influences, and so I think that the functioning of the administrative justice system in the UK or in Australia and in France, Italy, or Germany has so many interchanging commonalities and differences that go well beyond the traditional opposition between common law and civil law countries.
Okay, thank you for your clarification. I don't know if there's any question for the audience. Yes, Oren, you have a question or a reaction, please.
Just to get the ball rolling, I hope other people will intervene because we have a bit more time. But I wanted to say two things. One, in reaction to something Trevor had said about the kind of boundaries between constitutional law and administrative law, or what is administrative law. I think it's a really important question that we haven't yet tackled enough. I mean, we have a kind of a basic grasp. This is about the executive. Administrative is about the executive, about administrative agencies, about regulations. But the processes, I think it was a kind of in vogue at some point of the constitutionalization of administrative law and the potential administrativization of constitutional law, that more and more perceptions from administrative law kind of penetrating for constitutional law is potentially another future kind of question for the field. And, in my kind of as I think of things, we have now the boundaries of a kind of a comparative constitutional law world and a comparative administrative law world. But at some point, it would make sense to start thinking about, I think, unifying them, to think about comparative public law. We might have kind of are still retaining too much of a kind of crisp lines between the fields. And one thing that we might do at the end is kind of think about just, what is our public law, and kind of and see administrative law and constitutional as just specialized branches within the bigger issue of public law. And another point that I wanted to say, I actually, so this is a reaction to what Leonardo had said about the kind of, as in response to the kind of methodological challenges that I think both Mariolina and Trevor put up, which are kind of like, about the difficulties of doing comparative work, and about the kind of potential neglect and complexities of jurisdiction choice. And I actually really like the response, Leonardo, that you made. You said it's not a response, but it was a response, I think. The response was, I am careful, I am aware of the complexities, and I'm reflecting my own kind of biases in the work. And once you do that, you are kind of, I think that the message that what I wanted to emphasize is that this is, I think, a good message for people who are interested in comparative work to kind of embrace. There are a lot, so the message is, don't lean too much on the difficulties of doing comparative law. You're welcome to engage in it as long as you're kind of quite clear and open about the potential biases and difficulties. Do the work. Others will judge the value of the work, and the work itself would be good as long as you're careful, contextual, and modest.
Thank you very much. Can I just chip in? And sorry if I abuse my position, but it's something that came up when I was reading the book. And it's also going in the directions of the questions that we are discussing between politics and law, between constitutional and administrative law, and the future of the field, especially with regard to the development of new technologies. At one point, pages 173 to 176 to be precise, you use this term, the ultra state, with respect to administrative law systems. And I think in that part of the book, it is very much connected to something like international or global organizations. But then when I was reading that part, and when I listened to the discussions right now, I have this question: what is the ultra state for you? Is it something like a different type of state, like beyond the usual Westphalian liberal states that has developed in the Western world as from the 17th century onwards? Or do you have kind of a specific idea of the ultra state, and this kind of blurring maybe between the constitutional and the administrative spheres, or what is it that you have in that concept?
Yes, the relationship between constitutional law and administrative law is, of course, a key issue, and we decided to devote attention to the constitutional framework and to the constitutional foundation. I have to reveal that Armin Bogdandi gave us a marketing suggestion, saying, why don't you call it a comparative public law? Trust me, you will have much more readers and buyers of this book. Probably he was right, but I felt the need to sustain the development of comparative administrative law. So I didn't want to, let's say, lose the specificity of the perspective of this book, merging in a broader comparative public law. But it's true that, of course, these are to some extent artificial distinctions and separations. However, of course, our main focus remains the functioning of the executive power and of the other administrative organizations, and the regulation of day-by-day management of government. And this is the reason why we decided to maintain administrative law rather than instead of public law. Of course, when we move to the supranational level, at the European Union level, or at the global organizations level, these distinctions become even more difficult, also because both Europe and international organizations do not have a constitution. But I think we must be very careful. This had been said also by the commentators before earlier, that we must not always adopt the lens of national jurisdictions to analyze and try to understand the functioning of supranational and international organizations.
Leonardo, do you want to add something to that, or?
No, thank you. Not on this. Not on this point. I just would not on this last point. But I'm glad that my point, my non-answer, was seen in the positive way, and not as in. I mean, not agreeing with Mariolina, because that was, of course, not the point.
Thank you very much.
We don't want to deter people from doing comparative administrative law, but just emphasizing how difficult it is. It is difficult, but you can manage through it. So that's the message. Yeah.
Thank you very much. Any other question from the audience, or any reaction among you as speakers? Yeah. I think we have had a very stimulating and fruitful discussions, and I think the book is clearly rising as a landmark in the field and the community of comparative administrative law. So let me thank you, Giulio and Leonardo, for all your efforts and what you provide to the community as a starting point and building block for future research, teaching exercises and the like. And thank you also to Oren, Mariolina, and Trevor for engaging so constructively, I think, with the book, offering all the insight from your experience and different viewpoints. So I think this is a real amazing start for what we try to do as a community of comparative administrative law. And I hope you have learned from it, enjoyed it a lot. We hope that this will be the first experience in a longer kind of meetings and discussion. We will try to do that again in the next academic year. So we would like to invite you to be in touch with me, for instance. If you have any kind of book of wider significance, relevance for the field, and that you would like us to engage and to organize similar discussions, it would be great to hear from you, so that we respond to your needs or your interest, or books that we don't know because they may come from a different part of the world, a different corner that we may not be as familiar with. And we are very eager to know. And I think Trevor and I will maybe make the next steps to try to organize an event around that suggestions. So we have also suggestions, of course, but it would be nice to have external input from you. So thank you very much. We will put the link also from the recording together and share it with you in the upcoming days. Thank you very much.
Thank you very much. And if I may add, we remain fully available with Leonardo to provide any other answer or comment to everyone. Will ask and send us an email to our email addresses. Thank you very much once again for organizing and participating at this conversation.
Thank you very much for these last words. That's great. Thank you.
And thanks, Isolde, for
Thank
expert
you.
moderating and
Thank you.
sharing the panel.
Bye bye. Thank you, everybody.
Bye.
Thank you very much. Goodbye.
Bye.